Now, during his presidency, Trump appointed 231 judges to the federal bench, which was an impressive number. One of the most successful parts of the entire Trump administration was his reshaping of the federal judiciary. It was, in many ways, the reason so many conservatives held their noses and supported Trump, the promises he made and the promises he kept about filling the courts with conservative judges. So Aileen Cannon was a part of that broader Trump success story at the courts. But if you were a Democrat, and honestly, even if you were a Republican, there were reasons to oppose Judge Cannon's appointment, reasons that went beyond ideology. At just 38 years old, Aileen Cannon had very little experience for someone nominated to be a federal judge, very little. She had never held a judgeship before, federal or otherwise. She had worked as an assistant U.S. attorney in Florida for a few years, but only 4 of the cases she worked on during that time went all the way to a jury verdict. And she had been the lead prosecutor on just 2 of those cases, both of them about firearms. The rest of Ms. Cannon's resume was similarly sparse. As the New York Times reports today, a Senate questionnaire asked for every published writing she had produced. She listed 20 items. Of those, 17 were pieces she had written in the summer of 2002 as a college intern at the Miami Herald's Spanish-language sister publication, El Nuevo Herald. Now, typically, when judicial candidates are asked for works they have published, they cite law review articles or opinion pieces about jurisprudence and legal theory. For example, the Senate today confirmed Biden nominee Dale Ho to a federal judgeship in the Southern District of New York. His Senate questionnaire included published writing like voting rights litigation after Shelby County, mechanics and standards in Section 2 vote denial claims, and silent at sentencing, waiver doctrine, and the right to present mitigating evidence. By contrast, Aileen Cannon offered old newspaper articles she wrote with titles like Flamenco, an explosion of energy and passion, and winners in the library quest competition, and tomatoes may reduce tumors. So it was an unusual set of writings for a lifetime appointment to the federal bench. The New York Times also reports that the questionnaire also asked her to provide all reports, memorandums, and policy statements she had written for any organization, all testimony or official statements on public or legal policy she had ever delivered to any public body, and all of her speeches, talks, panel discussions, lectures, or question and answer sessions. Aileen Cannon's response to that section? None. Despite all of this, she was confirmed on November 12th, 2020, and her short time on the bench has not added much in the way of experience. According to the Times, just 4 criminal cases that have come before her as a judge have ever gone to trial. And all of them were routine cases, like a felon who was charged with illegally possessing a gun. Those 4 cases amount to just 14 days of trial experience in total. You have probably heard by now that Aileen Cannon is the judge who has been randomly selected to oversee the DOJ's indictment of the former president. And so far, there has been a lot of focus on any perceived bias toward the president who appointed her. She's a lifelong conservative and a member of the Federalist Society. And of course, during the early stages of this investigation, Judge Cannon made a consequential ruling against DOJ investigators and in favor of Trump and his defense team that prohibited the government from reviewing any of the documents obtained in its court-authorized search of Mar-a-Lago, and essentially delayed the investigation for 3 months before it was overturned by the very conservative 11th Circuit Court of Appeals. So a lot of folks here have been concerned about bias. But looking at this reporting from the New York Times, the articles on flamenco dancing and tomato-based cancer cures, the fact that Judge Cannon has been on the federal bench for just 2 years and has overseen just 4 trials in her lifetime, not one of them having to do with national security matters. Perhaps that is the stuff we should be focused on, as this judge oversees one of the most consequential, complex criminal cases in American history. Joining me now are Neal Katyal, former acting U.S. Solicitor General at the Department of Justice, and Barbara McQuade, former U.S. Attorney for the Eastern District of Michigan. Both are MSNBC legal analysts. Neal, can we talk about the case in terms of what makes it different from most cases? And, you know, what the thorniest aspects of this are? Are they the questions of executive privilege? Are they the classification, national security implications? Is it just the actual defendant and who he is? I mean, what do you think about this case is trickiest on its face?
Yeah, there isn't any executive privilege issue. I mean, Donald Trump sees executive privilege in anything, but back in the reality-based world in which you and I live, there's no executive privilege claim in this case. I do think that the classified information privileges are important. Classified information issues are going to be difficult and take some time. And it's there where you really want experience. I mean, the fact that she's had 4 prior criminal trials is one thing, but to really have no prior experience with classified information is, I think, a real problem, because anyone who's worked and handled classified information, you know a couple of things. You know there's such an extensive set of rules for prophylactic reasons, because bad guys, foreign enemies, terrorists, others are trying to get access to our intelligence information. So it's got to be protected in certain ways. But also you come to appreciate how that information was generated, the so-called sources and methods that generated. And you can see a document that is classified, and it almost looks like a New York Times article. You know, it doesn't look that different. And indeed, you might have read much of it in the New York Times. But the way in which it's put and presented may reveal a source, may reveal a method, and jeopardize lives in the field if that document comes out or falls into the wrong hands. And so that's why you have such a robust prophylactic set of rules. And here, in this criminal trial, Trump will try, presumably, a gray mail strategy. That's the strategy of saying, look, you're saying there's a classified document I mishandled. You got to show it in open court. And our intelligence community is always worried about that, again, because that itself discloses sources and methods. So there's a long compromise and dialogue between the Justice Department and the intelligence community in any sort of criminal trial. And one thing that happens sometimes is that you substitute, under the Classified Information Procedures Act, a sensitive document for something that looks like that is less sensitive, or that redacts the information in a way or another. Those are all things you really want someone with experience to handle. But unfortunately, it looks like at this point, that's not what we have.